Hello aspirants, our today's topic for focus of the day's discussion is the sealed cover jurisprudence. We will see why in news, what is sealed cover jurisprudence, what is the legality of this, what are the arguments in favor, arguments against, then we will see some of the previous cases in which this was used. After that we will see previous Supreme Court's observations over this matter, as this matter is crucial nowadays. Then we will come to the conclusion, and after that we have our two prelims practice question for the today's session. So we'll start with why in news. Recently, the Supreme Court rejected the Union government's suggestions regarding the information of a committee to inquire into Hindenburg report on the Adani Group, which was offered in a sealed cover. I have given you a video on the Hindenburg report as well, so if you want, so you can go through it as well. The regular use of sealed covers has resulted in loss of public confidence in the judicial system and the administration of the justice due to its opaque nature. What is sealed cover jurisprudence? Sealed cover jurisprudence is a legal mechanism that reflects to act of submitting confidential or sensitive information to the judicial body, be it a court or tribunal, in a sealed cover. The cover is meant to be opened and reviewed only by the judges presiding over the case. The use of sealed covers began with administrative or service cases where official service records and assignments of officers were provided in sealed covers to prevent damaging the reputation of that officer. So this was the reason that they were started. The courts have made use of this mechanism to receive reports in cases of sexual abuse so as to protect the privacy and dignity of the victims. It is normally used in only one of the two situations. First is ongoing investigations that are a part of police general, and disclosure of confidential or private information. In both the cases, the premise is clear. The court processes must not jeopardize the investigation, or it may not cause injury to a party by releasing such information. What is the legality of this sealed cover jurisprudence? Under Rule 7 of the Order 13, Supreme Court Rules 2013, the Chief Justice of India of the court can, through a judicial order, direct that any document be kept confidential via a sealed cover if publication is not in public interest. Section 123, the Affection Act of 1872, has stated that the government must give prior permission to any person desiring to give evidence derived from unpublished official records related to any affairs of the state. Section 123 also protects official unpublished documents relating to the state affairs and prohibits the public from being compelled to disclose them. It also mentions publication impedes on ongoing investigation as an acceptable reason to risk sealed covers. Example, case diaries. What are the arguments in favor? Our Supreme Court's jurisdiction has been enlarged to include the ability to receive case information in sealed envelopes. This is done in highly sensitive instances like defense deals or policy related cases that will have a significant impact on the country's economy. In these situations, sealed envelopes become critical and their use is unavoidable as a matter of national security. Courts have in-camera procedures even in the private cases nowadays. This is because even situations involving people's personal lives are not admissible in the court records. What are the arguments against? Lack of transparency. Sealed cover jurisprudence can limit transparency and accountability in the legal process, as the evidence or arguments presented in the sealed cover are not available to the public or other parties, like opposition party is not able to access the information. Then disparate access. The use of sealed cover jurisprudence can create an unequal playing field, as the parties who have access to the information in the sealed cover may have an advantage over those who do not. Then there is limited opportunity to respond. The parties who are not privy to the information in the sealed cover may not have the opportunity to respond to or challenge the evidence or arguments present in it, which can undermine their ability to present their case effectively. It is against the right to know. The doctrine of sealed cover definitely goes against the citizens' right to know. It excludes the public from crucial issues that impact their lives directly or indirectly. Reasoning not given by Supreme Court, it is also an argument. The court's order provides no justifications for using sealed cover practice. There isn't even a verbal commitment to access if the public interest is better served by disclosure of the truth. It manipulates the final decision. It vitiates the decision making process and affects the outcome. Sealed covers have been allowed in cases where facts presented by the state needed to be debated and examined to settle the question of the law. What are the previous uses of this? So you can pause the video, you can just read this. This was in BCCI reform case, Bhima Koregaon case, Unlawful Activities Prevention Act in that. Now Rafale fighter jet deal, National Register of Citizens. In the Gyanvapi case as well, this was used. So you can pause and read it further. Now, what are the Supreme Court's previous observations on this? In the P. Gopal Krishnan versus the State of Kerala case of 2019, the Supreme Court held that the disclosure of the documents to the accused is constitutionally mandated even if the investigation is ongoing and documents may lead to a breakthrough in the investigation. INX Media case of 2019, the Supreme Court had criticized the Delhi High Court for biasing its decision to deny bail to a former union minister on documents submitted by the Enforcement Directorate in a sealed cover. It held the action as against the concept of fair trial. Then CDR Amit Kumar Sharma versus Union of India case. The Supreme Court said the non-disclosure of relevant material to the affected party and its disclosure in a sealed cover to the adjudicating authority sets a dangerous precedent. The disclosure of relevant material to the adjudicating authority in a sealed cover makes the process of adjudication vague and opaque. What is the conclusion? The sealed cover jurisprudence needs to be balanced with principles of due process, fair trial and open justice. The jurisprudence concerning sealed covers is currently in a grey area. So some people like and some people don't like it. The use of this legal mechanism must be subjected to the circumstances and requirement of the particular case and not be blindly used like this government is using in any attempt to gain an advantage. Courts and tribunals should also ensure that the parties who are not privy to the information in the sealed cover are given a fair opportunity to present their case and challenge the evidence or arguments presented in it. Now we will come to a prelims practice question. Which of the following is concerned with the Supreme Court of India? Pause the video, try to answer. So basically all 3 is the answer. So your answer is 4, which is all of the above. Second question, the Supreme Court has affirmed that it can order the restoration of the State Assembly dissolved by presidential order in the case of. Try to search all the cases and type the answer in the comment section. So this is a homework for you guys. This was all about today's video. Thank you. Have a nice day and stay tuned for the next topic.